All right, well, again, thanks for being here tonight. I am Carrie Renner. I'm an estate planning attorney and I own Provision Law Firm in Burnsville. So basically what this means is that I am no stranger to conversations about death and family and money and the risks and quite frankly, the fears that exist when all of those things come together. So I would like to start off tonight by congratulating all of you. You're here. And I know that this first step is a big one, because for most people, getting a will or discussing estate planning generally is something that's been on their mind for a long, long time. But about half of all people never actually get their estate planning done. And so what that means is those people miss out on the opportunity to plan for end of life, and they die. And their wishes were never known or were never implemented. So I just want to take a minute and think about how life is really the same for all of us. We're born, we live, we die. We have these bookends of life, right? Birth and death. And I would be willing to guess that most of the people here have been to a baby shower. Well, at least the women have probably been to a baby shower. I bet some of the maybe younger women have even written a birth plan. Because the truth is that we prepare for birth. We talk about it, we celebrate the life that's about to be, and we just don't do the same for death. We avoid the subject and we fail to plan. We really pretend as if it's not going to happen, even though we all know it is. We are all going to die one day. So this delusion that we have, and maybe for some it's optimism, I don't know, but that there's always going to be another tomorrow, it really paralyzes our ability to plan for the inevitable. I also believe that in large part, people just don't understand how planning is going to help. They don't know how it's going to make a difference in the lives of those that you love. Number one, no one has helped you identify your goals. What are your end of life planning goals? And number two, if you have identified those goals, no one has told you how to accomplish them. That's not going to be the same for everybody. So we are going to start off tonight by taking a moment to identify your goals. So if you haven't already, I'm going to give you just a second to grab a pen and just a scrap of paper. You can number those. I think we've got 7 questions and you need very little space. But while you grab that, I am going to begin my screen share. We're going to take a quick survey. Okay. All right. Looks like that showed up okay. All right, so hopefully everybody had a chance to grab a pen and a piece of paper. And we are going to start by identifying some of your goals. So what we're going to do is you're going to score these questions on a scale of 1 to 5. 1 being this is something that's not at all important to you. 5 being something that is very important to you. So number 1 says, how important is it to you to protect your privacy at death by preventing your assets, your debts, the beneficiary selections, and your wishes from becoming public knowledge when you die? 1, 2, 3, 4, or 5. All right, number 2, how important is it to you to protect the privacy of your loved ones when you die by preventing their personal information and information about their inheritance from becoming public knowledge? Number 3, how important is it for you to provide for a quick, low-cost, low-stress administration of your estate when you die and to keep your family out of court? Number 4, how important is it to you to protect the assets you leave to your loved ones from creditor claims that they have and from a divorce that they may experience? Number 5, how important is it to protect the assets you leave your loved ones from immature decisions by the recipient, inexperience managing money, addiction issues, or a mental health impairment. Number 6, how important is it to you to maximize the assets you leave behind and minimize the taxes your estate pays? And lastly, number 7, how important is it to you to preserve the family harmony after you're gone? So what did all 7 of these questions have in common? They're all about taking care of the people you love. So now you have a sheet full of numbers. Take a look at it. Do you have some 4s and 5s on that sheet? If you do, then what that means is that there are issues that are very important to you, issues that your estate plan can address. If you have all 1s on your sheet, then estate planning might not be something of high value to you, and that's okay. We are all different and we all prioritize things differently. So where do we begin? How do we accomplish the goals that we've just identified? These are the things you can see here that we're going to cover tonight. Number 1, an overall plan. Everyone should have an overall plan of how things are going to transition after their death. Second, you need a wealth transfer plan. So this is typically going to involve a will or a trust. You need an understanding of what probate is. And then lastly, you need to have a healthcare directive and a power of attorney, and we'll talk a little bit more about that right now. So that's what we're going to start with tonight is healthcare directives and powers of attorney. We often refer to these 2 documents and a couple others that we typically add to the mix as incapacity planning. And that is because these documents are there to take care of you if you ever become incapacitated. And these documents lose all of their authority at your death. One exception to that is that your healthcare directive does express your wishes regarding cremation or burial and organ donation, and so that does extend very briefly after your death, but for the most part, these planning documents are going to end at death. Here is a side note, a tip for anybody who has been operating as a power of attorney for a loved one. If that person passes away, your authority as power of attorney stops. So don't continue to go to the bank and withdraw money or operate as POA if that person has passed away. All powers of attorney end at death. A healthcare directive is the document that you use to authorize someone you trust to make medical decisions for you if you can't make them for yourself. So you may have heard these referred to before as healthcare powers of attorney or living wills. We now have combined those into one document. We call it a healthcare directive, and it comes in 2 parts. In part 1, you choose your healthcare agent and a couple of things related to organ donation and disposition of remains. And in part 2, which is an optional part of the healthcare directive, that is where you can lay out all of your wishes for your care. So this might include situations when you would not want life-sustaining treatment. It might be specifics about your organ donation wishes, could be your religious beliefs. There's a long list of things that you could include in that part 2 of your healthcare directive. A healthcare agent has no authority over your financial affairs. So you will also need a durable power of attorney. Now, what the term durable means is that that power of attorney will continue through incapacity. There are many, many types of powers of attorney. There are limited, there are durable, springing, statutory. There's a form for every scenario you may need. So it's really important to know what's going to work well in your situation, what types of assets you have, what authority do you want to convey, and have the power of attorney that's right for you. I cannot emphasize enough that every single adult should have a healthcare directive and a power of attorney. Healthcare directives and powers of attorney are documents that have nothing to do with net worth or age or stage of life. Really, if you've attained 18 years old, you should have these essential documents in place. Never assume that as a parent, you're going to be allowed to make decisions because it's your child. Same thing for spouses. Don't assume that just because you're married that you're going to have authority to make those decisions. Without these two very important documents in place, your family could find themselves in court fighting for a guardianship or a conservatorship to take care of you or take care of your financial affairs. One tip is to encourage high school graduates heading off to college to encourage them to execute a healthcare directive and a power of attorney. It's every parent's worst nightmare to receive a call from a hospital announcing that they have your son or daughter there, but that they cannot share any of the details of their condition. Having these simple documents in place is going to change everything. Okay, we're going to switch gears now, and we are going to talk for a minute about probate and wills and trusts. These things don't have to do with incapacity planning. Instead, they have to do with the transfer of wealth that occurs at death. So the word wealth, it's funny, people don't like the word wealth. Everybody tells me that they're not wealthy if I use the word wealth. They all tell me that their estate is simple. So I often need to remind people that each of us has, number one, more than we think we do. We have a household full of stuff. Some of it is sentimental, some valuable, a lot of it is junk. But in addition to that, we have a home, a car, savings and checking accounts. Many of us have retirement accounts or other investment accounts. Some people own a business. A lot of people in Minnesota have a cabin up north, or you be a beneficiary of someone else's estate and be inheriting money in the future. You might have a life insurance policy to a beneficiary at your death. With your wealth, that's all part of your estate. So these assets, they need to transfer at your death. In addition to the assets, you've got people or charities or even pets that you care deeply about. So when you are creating an estate plan, you're going to decide who your assets will go to and when and how. That's all part of the planning. As we begin to address the who, when, how, it's important first to really understand what is the concept of probate. So what is probate? Probate's a court proceeding. It's used to transfer assets when someone dies. So it is not that every estate needs to go through probate. Usually a probate comes about because the survivors of a family member ran into red tape somewhere. You know, it might go something like this. Mom passes away. Mom had a will. It said, I leave everything to my children. The kids get a death certificate. They head down to her bank and they tell the bank teller, hey, here's mom's will. Here's her death certificate. It says we get everything, so we'd like to withdraw the money out of her account. And the bank teller looks at them and says, well, I'm sorry, but you don't have any authority to withdraw this money. You need to become a personal representative, and you do that through a probate proceeding. That's the red tape I'm talking about. That's when I get the phone call. What happens in probate? So generally speaking, aside from the complexity that's shown here, what probate is a time when the will, if there is one, all of the assets of the decedent, the debts of the decedent, any beneficiaries of their estate, as well as their addresses, those things are all filed with the court and they become public information. Probates almost always require a court proceeding, and those court proceedings, as you might imagine, are often backlogged. Hearing dates, I think, in Hennepin County right now are scheduling out about 5 months for an initial hearing. So everybody is just sitting patiently, waiting even for that first hearing for several months. Notice of the probate is published in a newspaper, in a legal newspaper, and that's so that creditors are aware that a probate's happening and that they're invited to make claims against the estate. There are waiting periods built into every probate, and typically people hire a lawyer because they want to protect themselves from any personal liability involved in the probate. So these proceedings, they usually take upwards of a year. They can be costly, and I think because of those things, they tend to be stressful for people. It's not very often that I meet people who say, oh yeah, my mom passed away, we had a probate, but it went just fine. No problem. Usually it's the opposite, and I hear, I had to deal with a probate, I want something different for my kids. One myth that I often dispel is that having a will is going to eliminate the need for probate. Wills do not avoid probate. In fact, the word probate is Latin for to prove, usually used in the context of to prove that a will is valid and that it's the person's last will and testament, that there isn't something newer lingering out there somewhere. So now that you understand a little bit more about probate, let's talk about the foundation of your estate plan, the method that you will use to transfer assets at your death. Will that be a will? Will that be a trust? Will that be something else? Will you do nothing? Let's talk about that for just a minute. So everyone has heard of a will. We're now clear that assets passing via a will are going to go through probate, most likely. But what can a will do? First and foremost is that a will is the document where you would name a guardian for your minor children. So if you've got kids under the age of 18, it's very important to have a will and to be able to choose who would raise your children if you were to have an untimely death. Second, wills allow you to choose who the beneficiaries of your assets are going to be. It allows you to choose who your personal representative is going to be. That's what we call executors in Minnesota. And it will allow you to request a more informal type of probate. So this could mean that you're asking the court to not require that a bond be posted by the personal representative, that it go through a registrar process rather than a judge. Those are requests and are sometimes followed if you have indicated that in your will. Let's compare that for just a minute to a trust. I'm often asked, why does a will have to go through probate and a trust doesn't? And I'm going to try to explain the difference. So what a will is, it's a set of wishes that purports to be your last will and testament, your last wishes. But a court needs to review it. They need to be sure that it was executed properly, that there isn't a newer document out there replacing it, there was no undue influence. So there's factors that the court is going to look at in order to validate that will. A trust, on the other hand, it's a legal entity that actually owns property. So this ownership by the trust, it might occur while you're living through a change in title. It might happen upon your death through a beneficiary designation to your trust. But in either case, you are taking the action to transfer ownership of your property into this legal entity that is your trust. So when you think of a revocable living trust, think of it like this. It's similar to a box, and you are unique, your family's unique, your assets are unique, and so your trust is going to be unique. The box that is your trust is not going to look like your next door neighbor's because you're different. Now, think of that box as having the cover off or that box being open. And that is the concept of a revocable living trust. So what that means is while you are living, you can freely take assets out of your trust, put assets into your trust, you can sell things, you can give them away. There is no protection here from creditors or from divorce. When you die, the cover gets put on the box and the trust now becomes irrevocable. No one, not creditors or anyone else. I'll just one caveat is that Uncle Sam is always excluded from anyone else because Uncle Sam is going to give their tax money one way or the other. So, but for the most part, no one is going to access the assets of your trust unless the terms of your trust allow for that. And those are the terms that you created while you're living. So maybe your trust says, I want my children to get money for college and rent or a down payment on a home or medical care until the age of 30. And then at 30, I want them to get the money. Well, those are the rules that the trustee then has to follow. I want to talk about who the players in the trust. In any trust, there's going to be 3 hats that are worn. First is that of the settler. That's the person who creates the trust. If you create a trust, you will be the settler while you're living. After you've died, nothing is ever going to change that. The second hat that's worn is that of the trustee. This is the person who manages the assets of the trust. And typically people want to be their own trustee, and often their spouse will be the trustee of their trust along with them. And they want that, but only while they have capacity. If they start to lose capacity, they're not quite understanding their money anymore, they're not quite understanding the world anymore, they've become vulnerable, they typically want to relinquish the ability to continue to be trustee. And of course, after they've died, they can't manage the money anymore or distribute it. And so somebody else takes over at that point. And then the third hat, that's the one everybody wants, the role of beneficiary, the person who gets to enjoy the assets of the trust. And it's important for everybody who creates a trust to remember that you are not giving anything away until after you have taken your very last breath. It doesn't matter what condition you're living in, whether you're in a nursing home, what your state of mind is, you are always the beneficiary of that trust as long as you are alive. So let's talk about what a trust does. And there's just some highlights here. A trust does a whole lot of things. Um, Pretty much, if you can think of it, it can do it with some exceptions that we might get into during the question and answer period. But these are the things that we want to cover tonight. A trust will allow you to maintain your privacy, create efficiency in the administration of your estate. It offers creditor protection, provides a safety net for beneficiaries, and it maximizes the assets to the beneficiaries while also minimizing the taxes. So that's what we're going to dive into now. First, a trust is private. So only your beneficiaries and the trustee are entitled to know information related to your trust. This would be things like the assets and debts, who your beneficiaries are, who your trustee is. And that, of course, as we talked about, is different with a will. A trust is efficient. Again, unlike a will, a trust does not need to go through probate. So this means that the administration of a trust is quick, low cost, low stress. Essentially, once the death certificate is issued, the assets can be transferred. A trust offers creditor protection. Unlike a will, a trust holds assets. As long as the money is in the trust, it's protected from things like creditors of the beneficiary, a divorce of the beneficiary. Keep in mind that this creditor protection is not offered to the beneficiary of a revocable trust, only to the beneficiary of an irrevocable trust. But remember, what we talked about is that your trust, your revocable trust, will become irrevocable when you die. So your children can be offered this kind of protection. A trust provides a safety net. Unlike a will, a trust does not need to distribute all of the assets by the age of 21. It can provide a safety net for your kids. So think, and this is kind of an extreme analogy, but think for a minute, when your kids reach the age of 21 and you're living your healthy life, would you ever consider saying, okay, I've calculated that I'm going to live another 30 years and I'm going to spend this much money on you during that time. So here you go, take it, and there won't be anything else. Of course not. We would never do that. But leaving money to kids through a will can be very similar to that. You've taken away the safety net. There won't be anything more. When they get that inheritance, that is it. And so if they are of a younger age or an age of less maturity, less experience, they may need a safety net down the road, and they won't have that anymore. Let's look at the next one. A trust maximizes assets and minimizes taxes. A trust administration does not have a lot of the same expenses that a probate administration has. So there are going to be no court costs, no publication fees. The administration often does not require the help of a lawyer. Also, a trust is often set up to maximize estate tax exemptions. So this means that the total tax bill is going to be reduced. A trust preserves family harmony. Do you want your kids to have to work together on paying the expenses at your death? Deciding who's going to kick in for the funeral, who has enough to contribute to the headstone, who's willing to pay the expenses of the home until it can be sold. What about the attorney, the CPA? Maybe there's other professionals who need to be brought in to help. With a trust, you can set a pot of money aside to cover these expenses before any of the inheritance is paid out. So the kids won't need to work it out themselves because you've already planned for it. All right, so wills and trusts, of course, are not the only ways to pass assets. There are other ways as well. I bet people listening tonight probably have beneficiaries on retirement accounts or life insurance policies. Maybe you've got a payable on death, transferable on death designation on some of your accounts. I bet a lot of married couples own their houses jointly or a checking account jointly. Those are other ways to transfer assets. The right tools, the right method of transferring your assets is really going to come back to your goals. And this brings us to the final aspect of planning, and that is the plan. Your overall plan should lay everything out. It should really untangle that financial ball of twine that we all create during our lifetime. So here's some things that you want to make sure that you include in your plan. You want to let people know where do they find the legal documents. In addition to your estate planning documents, you've got birth certificates and death certificates. You've got titles, deeds. There's other legal documents that people may need to get to. You want to inventory all of your assets. This means how do they locate, what do you have, how do they locate them? Do you do that online? Do you have a financial advisor? Make that as easy for them as possible. You have insurances. You've got homeowners insurance, car insurance, maybe life insurance. You might have a pension. Those are things that your family is going to need to know about. You've got financial responsibilities. Those oftentimes are going to be related to the home, vehicles, but you may own a business. You may help support another person. Those are things that people need to know about. You've got personal responsibilities. Maybe you have a pet that needs to be cared for. You may have an elderly parent, a neighbor, a disabled child. There's all kinds of personal responsibilities that if you die or even have a short period of incapacity, things will go much more smoothly if people know what those are. You have a whole digital world. That's a whole nother area that you need to be thinking about in your plan. Providing usernames and passwords, but also giving somebody the authority to access those accounts so that they're not breaking any rules. You need to lay out your key contacts. So that's not just your attorney or your CPA and your financial advisor, but those are family members, neighbors. They may be people who help take care of the house or help take care of you. Though that could go all the way down to your hairdresser. Whatever is important to you should be included. That information should be provided to your loved ones. Okay, and you have the opportunity to do some funeral planning. I think it's a great idea to pre-plan, either by prepaying for cremation or burial. But if not, then laying out your wishes. What are the family history information that they're going to need to come up with? What are your wishes regarding your funeral, your celebration of life, a headstone, a plot location? All of those things can be laid out in advance. And then I think one of my favorite parts of planning is helping people get started on a family letter. You sometimes will hear this referred to as an ethical will. It is not a legal document. If it conflicts with any legal document, then the legal document is going to control. But this is a chance for you to tell about yourself and to remind everybody that you are more than the assets that you left behind. You had a life, you had things that you were proud of, values that you held dear, and those should be part of the planning. I would say that for people who take the time to write a family letter, not only is it a beautiful gift that can be found after a person passes away, but it also really tempers the mood when it comes to difficult issues during the administration. So I want to thank you all once again for taking the time out of your day to be here tonight. Estate planning is really a very selfless thing to do. You all clearly care about the people in your lives to be here tonight, so I thank you for that. I will put in the chat in just a minute, I will put a link to schedule a free one-on-one consultation with me if you would find that beneficial. But I also want to take the time that I promised to answer any questions that you might have tonight. So I will end this screen.